Chief Justice Isa is his role in the conduct of general elections held on February 8, 2024. This court, under the leadership of the Chief Justice, paved the way for all stakeholders to agree on the set date for the conduct of general elections. This ensured that our country continues to tread the democratic path. There was yet another hurdle when the Lahore High Court, through order dated December 13, 2023, in writ petition 8083 of 2023, suspended notifications issued by the Election Commission of Pakistan, whereunder district returning officers and assistant returning officers were appointed. Had the suspension order of the Lahore High Court been allowed to hold the field, the general elections on February 8, 2024 would have been a virtual impossibility. Chief Justice Isa, without any delay, on 15 December 2023, suspended the Lahore High Court order and cleared the path to the general elections which were held, and our democracy was once again saved. In a nascent democracy like ours, the role of the apex judiciary is not only to preserve democratic values, but more often than not, it is to actively shield it from ever-evolving challenges. In his tenure, Chief Justice Isa saw democracy through a particularly turbulent time. Throughout his time on the bench, Justice Isa has promoted democracy, transparency, and accountability, not only generally, but also for himself and his own institution. I can say without hesitation, on the occasion of his retirement from bench, that his father, the late Qazi Muhammad Isa, one of the founding fathers of our country, would be proud. We wish him a happy retirement and hope that he will continue to serve democracy, rule of law, and constitutionalism post-retirement. Thank you very much.
Thank you, Attorney General. Now I request Mr. Farooq Hamid Naik, Vice Chairman, Pakistan Bar Council, to deliver his speech.
Bismillahir-Rahmanir-Rahim. Honorable Chief Justice of Pakistan, Justice Qazi Faez Isa, Honorable Justice Yahya Afridi, Chief Justice Designate, Honorable Judges of the Supreme Court, Mr. Mansoor Usman Awan, Attorney General for Pakistan, Mr. Shehzad Shaukat, President, Supreme Court Bar Association, distinguished members of the Bar Councils and Bar Associations, ladies and gentlemen, Assalamu alaikum. It is both an honor and a privilege to stand before you today as we gather to bid farewell to an individual whose career exemplifies principles of justice, integrity, and judicial independence. Today's ceremony not only marks conclusion of Justice Qazi Faez Isa's tenure as Chief Justice of Pakistan, but also reflects continuity of a tradition that strengthens our judiciary and reinforces its vital role in democratic fabric of our nation. This gathering is a moment to reflect not just on remarkable contributions of Justice Faez Isa, but also on the journey of our judiciary as a whole. Supreme Court stands as one of the three pillars that uphold the state alongside Parliament and Executive. The trichotomy of power ensures the rule of law remains at the heart of governance, safeguarding rights of people and sanctity of our Constitution. Since the birth of Pakistan, judiciary has played a crucial role in defining justice and governance. As one of the three pillars of state, alongside Parliament and Executive, it is entrusted with interpreting Constitution, protecting rights, and maintaining balance of power. Judiciary has evolved over time, adapting to societal changes while safeguarding rule of law. In its early years, judiciary worked within a legal framework inherited from colonial rule, gradually asserting its independence. Landmark decisions shaped democratic norms, though political pressures and executive overreach occasionally tested its autonomy. Yet, through these challenges, courts emerged stronger, ensuring civil liberties and justice in times of uncertainty. Independence of judiciary is the principle that judiciary should be free from outside interference and be able to make decisions fairly and impartially. This means judges should not be influenced by other branches of government, private interests, or partisan groups. Independence of judiciary is important because judges often decide matters between citizens and state or between state and powers of entities. In Pakistan, Article 2A of 1973 Constitution states that independence of judiciary judiciary should be fully secured. In Sharaf Faridi's case, Supreme Court explained that it is a duty of every judge to decide matters in conformity of facts and his understanding towards law without any influence and pressure. An independent judiciary is vital to protection of human rights. It is absolutely essential to resist undue influence and provide remedies for justice problems. Judiciary in Pakistan must provide an expeditious and inexpensive remedy in matters relating to ordinary litigants as well as matters relating to infringement of fundamental rights. Independence of Pakistan judiciary has changed over times, where judiciary used to defer to Pakistan's military by legitimizing martial laws and military dictators who were dominant actors in Pakistan politics. First Constitution of Pakistan, as passed by the Constituent Assembly, was framed in the year 1956, and preamble of the objective resolution could be termed as the grand norm of Constitution of Pakistan, which has incorporated securing federalism, parliamentary form of government, independence of judiciary and social welfare state. Objective resolution, which was passed in the year 1949, became part of substantive constitution by incorporating Article 2A in the year 1985. Unfortunately, our military dictators did not allow Constitution of 1956 to function and abrogated the same in the year 1958, and that very insurgency derailed democratic system in Pakistan. This unlawful act of the military dictator was unfortunately upheld by Supreme Court of Pakistan in Dawson's case, reported as PLD 1958, Supreme Court 533. Another constitution was framed in the year 1962, which too was abrogated by another dictator in the year 1969 through an unlawful and unconstitutional act, where elections were held and democratic government came into being in 1971, in which Shahid Zulfikar Ali Bhutto became Prime Minister, who promulgated Constitution of 1973, fully based upon democratic principles as well as based on other clauses contained in previous constitutions. This constitution was smoothly functioning, but however, another dictator abrogated in the year 1977 and remained in power for more than a decade. Once again, Supreme Court upheld such abrogation in Begum Nusrat Bhutto's case. In Government of India Act 1935, there was no specific provision about persons who have to be consulted before appointment as federal court judges. According to Act 1935, they were appointed by His Majesty by warrant under Royal Sign Manual, and they could hold office until age of 65 years. Constitution of 1956 provided that Chief Justice of Pakistan shall be appointed by President and other judges shall be appointed by President after consultation with the Chief Justice. With regard to the appointment of High Court judges, under Constitution of 1956, it was laid down that every judge shall be appointed by President after consultation with Chief Justice of Pakistan, Provincial Governor, to which appointment related, and if appointment is not that of Chief Justice of High Court. Constitution of Pakistan 1962 provided that Chief Justice of Pakistan shall be appointed by President and other judges shall be appointed by President after consultation with Chief Justice. Whereas Constitution of 1962 provided that High Court judge shall be appointed by President after consultation with Chief Justice of Pakistan, Governor of Pakistan, province concerned, and Chief Justice concerned, where appointment is not at that of Chief Justice. Since 1973, judicial system of Pakistan is being regulated under Article 175 of Constitution, which provides for establishment of Supreme Court and High Courts in each of the 4 provinces. Through an amendment to this article, High Court for Islamabad has also been established. Induction of High Court judges earlier was made on recommendations of respective Chief Justices after approval of provincial governor concerned. Thereafter, matter was sent to Chief Justice of Pakistan, and accordingly final approval was made by President through Federal Ministry of Law. This procedure was completely changed through 18th Amendment in Constitution of Pakistan by adding Article 175A, which provided for Judicial Commission comprising of judges of Supreme Court and High Courts, Federal Minister for Law and Justice, Attorney General for Pakistan, and representative nominee of Pakistan Bar Council and Provincial Bar Councils. After nomination was made by Judicial Commission, matters was referred to Parliamentary Committee consisting of 4 members from Senate of Pakistan and 4 members from National Assembly. And out of these 8 members, 4 were to be taken from Treasury benches and 4 from opposition. Committee had power either to confirm nomination made by the Judicial Commission by majority of its total membership or may not confirm nomination by 3/4 of its total membership. Now, 26th Amendment to Constitution has been promulgated, which has merged Commission and Parliamentary Committee. However, under 26th Amendment, a woman or a non-Muslim other than Member of Parliament who is qualified to be a Member of Senate as a technocrat has been added in Judicial Commission. The role of civil society has been given. After promulgation of 26th Amendment, independence of judiciary is not infringed. Independence of judiciary is obvious from the fact that tenure is fixed and a judge cannot be removed except on grounds as mentioned in Article 209 of Constitution by Supreme Judicial Council comprising of judges of Supreme Court and High Court. Similar is the case for removal of punishment of members of armed forces by courts established under the Pakistan Army Act 1952, and that also speaks about independence of institution of army. However, independence of parliamentarians is not secured. In case of inappropriate action by them, their removal or punishment is not by their own brother parliamentarians, but by judges. It is a historical fact that on false allegations which have been leveled against parliamentarians have led to the removal by judges of the past, and even governments were dismissed, and 2 prime ministers were removed through judgments of Supreme Court of Pakistan. Let us look into the mode of appointment of judges in superior courts in few other countries. In USA, justices of Supreme Court, Court of Appeal judges, and District Court judges are nominated by President and confirmed by US Senate. In Canada, justices of Supreme Court of Canada are appointed on Prime Minister's advice, and judges of provincial and territorial courts of appeal are appointed by provincial and territorial governments through judicial advisory committees, which are appointed by provincial and territorial government, in which there are nominees of government. In United Kingdom, there is a selection committee for selection process convened by the Lord Chancellor consisting of 5 members. In Australia, executive enjoys unfettered powers of judicial appointment. So, a Chief Justice holds a unique position in this evolution, not only for just interpreting laws, but also guiding judiciary through internal reforms and external pressures. Over years, each Chief Justice has left a distinct legacy, some reinforcing independence and others setting new constitutional precedents. Justice Qazi Faez Isa's tenure as Chief Justice demonstrated an unwavering commitment to transparency, judicial restraint, and rule of law. His leadership exemplified a careful balance of authority, contributing significantly to strengthening democratic principles and environmental governance. One hallmark of his tenure was his minimal use of suo motu powers, in stark contrast to his predecessors, who took dozens of such notices, on one with 64 and another with 57. Justice Isa used his power sparingly, reflecting his philosophy of judicial restraint and rejection of judicial activism, which he saw as critical to maintaining institutional balance. He was also a vocal opponent of judicial martial law, reinforcing judiciary's role in supporting democratic governance rather than intervening politically. Justice Isa rectified major unconstitutional decisions such as overturning lifetime disqualification of politicians under Article 62(1)(f) and addressing misinterpretations in Punjab government case related to Article 63A. His correction of historical wrongs also included revisiting Zulfikar Ali Bhutto's Shaheed's case, restoring dignity of judiciary and rectifying past injustices. Another important achievement was his handling of election-related matters. Justice Isa prioritized democratic integrity, ensuring that 2024 elections are held on schedule despite obstacles. His rulings compelled institutions to act according to law, preventing undue delay through judicial intervention. Supreme Court, under Chief Justice Qazi Faez Isa, formally resolved controversial dam fund issue by distancing judiciary from the project. Justice Isa ruled that responsibility for the project lies with the executive, while management of funds belongs to the State Bank of Pakistan. Court court-ordered transfer of collected funds, around PKR 23.67 billion, to public accounts of the Federation, ensuring transparency and proper state oversight. In environmental governance, his leadership was evident in rulings like Monal restaurant closure, where he underscored constitutional right to a clean environment. He framed environmental protection as essential to human dignity and ordered restoration of Margala Hills National Park with minimal disruption to wildlife. Justice Isa also presided over Faizabad Dharna case, which held various state agencies accountable for overstepping their roles. This bold decision reaffirmed the principle that armed forces and intelligence agencies must adhere to their constitutional mandates and avoid political interference. Through these contributions, Justice Isa has showed his ability to lead without overstepping his authority. He delegated powers to committee, avoided unnecessary administrative interference, and declined official protocol, ensuring that his tenure was marked by humility and fairness. His refusal to seek a tenure extension further exemplified his commitment to institutional dignity and principle that public office must be held in trust, not entitlement. And how can we forget Memo Gates, sir? Justice Isa's legacy lies not only in his judgment, but in his broader efforts to nurture judicial independence, promote transparency, and promote democracy. His tenure serves as a benchmark for future judicial leadership, inspiring a balanced approach towards justice and governance. A strong judiciary guarantees that no arm of state oversteps its authority, fostering accountability and ensuring justice for all. Under leaders like Justice Isa, judiciary has reinforced these principles by promoting transparency, independence, and timely decision-making, ensuring that democracy continues to thrive through fairness and impartiality. As we bid farewell to Justice Qazi Faez Isa, I reflect not only on his significant contributions, but also on values he embodied through his career: integrity, courage, and an unwavering commitment to justice. His leadership has left a lasting impact on our judiciary, inspiring future generations to uphold transparency, fairness, and accountability. Justice Isa's tenure serves as a reminder that strength of our institution lies in those who lead with principle. As I said, his decision to retire without seeking extension is a testament to his belief in the dignity of public office. Your Lordship, Honorable Chief Justice of Pakistan, on behalf of the legal community, I extend our deepest gratitude to you for your tireless service. As you embark on this new chapter, we wish you peace, good health, and continued success. Your legacy will remain a guiding light for the judiciary and the nation in the years to come. Thank you, sir.
Thank you, Farooq sir. I now request Mr. Shehzad Shaukat, President, Supreme Court Bar Association, to deliver his speech.
His Lordship, Mr. Justice Qazi Faez Isa, Chief Justice of Pakistan. His Lordship, the Chief Justice Designate, Justice Yahya Afridi, Honorable Judges of the Supreme Court of Pakistan, Learned Attorney General for Pakistan, Mr. Mansoor Usman Awan, our very distinguished Vice Chairman of the Pakistan Bar Council, Mr. Farooq Naik, Honorable members of the Bar, ladies and gentlemen, Assalamu alaikum. As His Lordship, the Chief Justice concludes his illustrious tenure as the Chief Justice of Pakistan, I, on behalf of the Supreme Court Bar Association of Pakistan, wish to extend our deepest respect and admiration for His Lordship's extraordinary contributions to the judicial landscape of Pakistan and the rule of law. Throughout his illustrious career, my Lord has exemplified integrity, impartiality, and unwavering commitment to the principles of justice and fair play. His Lordship's journey as a member of the Pakistan's legal fraternity spans over more than 4 decades, including 27 years as a practicing lawyer and a historic tenure as the Chief Justice of the Balochistan High Court. His ascent to the position of the Chief Justice of Pakistan reflects his legal acumen and dedication to the principles of justice. The landmark judgments delivered by his Lordship have left an indelible mark on our judicial landscape by safeguarding constitutional rights, promoting transparency, and applying the rule of law without fear and favor. My Lord Justice Qazi Faez Isa, you are a phenomenon that few could fully grasp. You are the first Chief Justice in Pakistan's history to have surrendered the discretionary powers of being the master of the roster to a committee established by an Act of Parliament, thereby upholding the supremacy of the Parliament in line with the constitutional mandate. Further, by focusing on the enforcement of laws and avoiding overreach into legislative prerogatives, the doctrine of separation of powers with the fundamental rights, which is fundamental to our constitutional framework, has been upheld. This approach reinforced the judiciary's role as an interpreter of law rather than the maker of law, which in turn had the effect of strengthening the pillars of our democracy. Your judgments in the cases like Faizabad Dharna highlighted your dedication to constitutional values, ensuring the protection of fundamental rights such as freedom of speech and expression, while also maintaining the importance of non-violence and peaceful assembly. Similarly, your meticulous handling of cases involving environmental protection, corruption and government accountability has showcased your vision for a Pakistan that upholds fairness, integrity and the rule of law. Additionally, your decision to definitively settle the issue of lifetime ban underscored your commitment to giving due weight to the actual text of laws and the Constitution. Not only did you decide old pending cases and references, but you also acknowledged the judiciary's mistake in Zulfikar Ali Bhutto's case by rendering an opinion in the Presidential Reference 1 of 2012. It was you, my Lord, who showed the willingness and courage to overturn bad law previously settled by the Supreme Court of Pakistan while interpreting Article 63A of the Constitution. We are all aware of the challenges you faced, including the 2019 presidential reference, which you courageously contested with utmost dignity. Your resilience in the face of adversity demonstrated the strength of character that defines you as one of the most respected figures in Pakistan's legal history. As you step down from your role, your legacy will continue to inspire generations of lawyers and judges. Your judgments, writings, and profound dedication to the public good will remain a cornerstone of Pakistan's judicial heritage. Your tenure is a testament to what it means to serve with honor and principle. On behalf of all those who have had the privilege to work alongside you and benefit from your wisdom, I wish you the very best in all your future endeavors. May your next chapter be as fulfilling and impactful as your time in the Supreme Court has been. Having said all this, I now take the opportunity to address the Honorable Chief Justice Designate, Mr. Justice Yahya Afridi, to highlight certain burning issues which I, on behalf of the Supreme Court Bar, have always endeavored to get resolved, being the representatives of the Bar. Firstly, may I once again request that immediate attention be paid to the delays in hearing of the cases, particularly stay matters, which delay is a cause of huge unrest in the legal fraternity as also the general public. I have repeatedly pointed out that a possible solution to the above menace can be adequately addressed by restoring chamber hearings of stay matters which are duly envisaged by the Supreme Court Rules 1980. Both the counsel and the client would thus be satisfied that their case was taken up for hearing expeditiously and will add to the grace and dignity of this Honorable Court and will also help alleviate the plight of the ordinary litigant. I may also point out that despite my repeated efforts, this Honorable Court has not adverted to the idea of extending video link facilities to all the benches of the high courts within the country, which will not only save traveling cost confronting the clients, but will also avoid unnecessary adjournments both in this court as well as the high court concerned in which the counsel is practicing. I may also emphasize that the quality of the available video link proceedings has a lot of room for improvement, which I am sure my Lord will take up on the first priority. I have been also requesting that an online procedure for issuance of certified copies be adopted forthwith. which my Lord had already achieved as the Chief Justice of the Peshawar High Court. Under your able guidance, I am sure that the Supreme Court will move further towards e-filing and digitalization of the record. My Lord, the Chief Justice Designate, has always been a patient listener and has always carried a smile on his face, which I hope